out today by Richard Walker. He is a senior judge for us in helping us out today. Now, let me introduce the case that we have. Case number 122061, Delaware Ridge Homes Association, Inc., appellee versus Deborah D. Maddy, appellant. Appearing for Delaware Ridge Homes, would you state your appearance?
Good afternoon, Your Honors. My name is Rod Hoffman of the law firm of Martin Pringle. I'm in Overland Park today.
Thank you. And appearing for the appellant, Deborah Maddy.
Good afternoon, judges. My name's Shane Lolich, appearing for the appellant, Miss Deborah Maddy, who is with me in the same room at a safe distance from me.
Okay, thank you. Now, Mr. Hoffman, well, the appellant, excuse me, Mr. Lilich, would you want you to rebuttal time or?
Yes, sir. I'd like to reserve 3 minutes, please.
Okay. And are you ready to present your argument?
I am, Your Honor.
We're ready to hear it. Okay.
Okay. Thank you very much. I'm going to start my timer. May it please the court, on behalf of the appellant, Ms. Deborah Maddy, I appreciate the opportunity to present our position today with this appeal. The appellant had sought at the district court level the appointment of a receiver in this case pursuant to KSA 60-1301 and KSA 60-1304. Her effort to obtain a receiver at the district court level was denied, and which brings us before this court. The record at the district court level is uncontested insofar as the appellee Delaware Ridge Homes Association compliance with the Uniform Common Interest Owners Bill of Rights Act in many respects. As we summarized in the brief, those respects include that the Homeowners Association never provided the homeowners an annual meeting, didn't maintain regular meetings of the Homeowners Association. There were never properly signed bylaws for the Homes Association, contrary to KSA 58-4608 sub A sub 1. The manner in which Delaware Ridge Homes Association conducted their business and affairs was contrary and deficient to Kansas law. That fact alone is exacerbated by the fact that the Homes Association did not provide the participating homeowners basic due process to participate in the Homes Association, as we pointed out in our brief. This proceeding in district court, insofar as the appellant is concerned, was defensive. The Homes Association had sued her for delinquent homeowners dues. So these issues were raised at the district court level to challenge the standing of the Homeowners Association to maintain the lawsuit to collect the dues. As by all appearances, the Homeowners Association is a sham, as it's not complying with the law. The Homeowners Association to date, to the best of appellant's knowledge, is still not in compliance with Kansas law or UCOBRA, the acronym for the Uniform Common Interest Owners Bill of Rights Act. and they continue to conduct the affairs of the homeowners association in a deficient manner and contrary to Kansas law. So the relief that has been sought by the appellant is the appointment of a receiver so as to transition this homeowners association from this space that it's in to put it on a more productive path in compliance with Kansas law. When the appellant sought that relief at the district court level, it was at a hearing October the 30th of 2018, and that motion that had been filed by me on behalf of my client was denied. In lieu of appointing a receiver, the district court appointed a facilitator, is what the district court referred to this person as, whose role was to transition the homeowners association over to the homeowners.
Let me just ask, right, stop you just for a second. What was
Yes.
your understanding of what a facilitator was supposed to do? It almost sounded like a combination of a special master and a mediator in all of this. How would you describe the role?
Well, this was my understanding of what Judge Mahoney's intention was. My understanding was that the role was limited to turning the homeowners association over to the actual homeowners from being managed by the developer. Did you have other questions in that regard?
Well, as I understand it also, I looked at your notice of appeal and his notes from the July 30 hearing that's in question. He not only took Ms. Bai out of the case, but then denied your request for a receiver. Is that right?
That is correct, Your Honor.
Okay, and that's what you're appealing from.
Yes, and just to clarify, that denial of the request from a receiver was from a hearing on October the 30th of 2018, which was subsequently journalized following a hearing in early August of 2019.
Okay.
Now, following that October 30th, 2018 hearing, there was a phone hearing January the 29th of 2019, which what happened during that hearing had never been journalized. And so in the reply brief that I filed on behalf of my client, I made reference to that, and that we were seeking to have that journalized so that this court could consider those findings. Following the filing of the reply brief on behalf of my client in July of 2019, I sought to have that hearing journalized. There were delays. I had suggested to Judge Mahoney's office that there was objections with respect to that journal entry pursuant to Kansas Supreme Court Rule 170. I had suggested to Judge Mahoney's office that he could simply resolve that journal entry without a hearing. Judge Mahoney wanted a hearing to resolve that journal entry, and that hearing didn't take place until March the 4th of this year. The findings from that hearing are still outstanding. I have followed up in that regard, which has led me to yesterday filing a motion to supplement the record once those findings are made by Judge Mahoney.
Counsel, I have a question.
Yes, sir.
How large is this homeowners association? How many homes?
I would say it's approximately 200 homes.
And what's the annual dues?
The annual dues are $200 approximately.
Okay, and your client has lived there for more than 10 years?
Yes, Your Honor.
All right.
Did you
Proceed.
have other questions, sir?
No, I just want to understand the facts. No, not at this point.
Okay. So as I said, that journal entry remains outstanding. Part of what happened at that hearing, and this would, I think,
I got another. Is the fact that journal entry is outstanding material to this case?
I
For this-
believe it is. I believe it is, sir.
Then how can we resolve the issue that you've appealed if there's an outstanding journal entry?
Well, I'm asking for more time to wait for Judge Mahoney to enter that journal entry so that I can supplement the record. And I filed that motion with the court yesterday. That hearing was March the 4th. I had followed up with Judge Mahoney's office on April the 16th by email. I followed up again May the 3rd. And that as I said, the journal entry remains outstanding.
And how is this going to help us decide whether a receiver should have been appointed? I guess I don't understand.
Well, at that hearing, Judge Mahoney dealt with the facilitator. Judge Mahoney made a determination, generally speaking, that addressing the issues with Delaware Ridge Homes Association and the transition was above the facilitator's head. It was more than she could handle. The facilitator that was appointed, and again, my use of the term facilitator, that is a term that Judge Mahoney assigned to this role, was a lay person appointed by Judge Mahoney, and issues came up with the transition of the homeowners association from the developer to the homeowners, and Mrs. Bai couldn't handle those issues. So as to Judge Schroeder's question, that journal entry is material because Judge Mahoney made findings with respect to the facilitator. At that hearing on behalf of my client, I requested that he reconsider the appointment of a receiver to, hopefully put somebody in place who would be more qualified to deal with the issues. And that request at that hearing was again denied.
Well, if we have a transcript of the hearing, why do we need to wait on a journal entry?
There was no record of that phone hearing. So the journal entry, to my knowledge, will be the only way for those findings to be memorialized for this court's consideration.
Okay, understood.
I'm happy to entertain any more questions that the court may have, but in looking at my clock, I see I'm approaching 12 minutes. And again, I would like to reserve 3 minutes for rebuttal.
I do have a question.
Yes,
The
sir.
judge seems to not deny the receivership because he was indicating that the cost, it would, as far it didn't justify appointing a receivership. Could you state some of the reasons why he felt, the costs would be more than would be a benefit as far as having a receivership?
Well, Your Honor, insofar as a remedy to this situation, there seems to be no alternative. The homeowners association continues to operate the association unlawfully. The cost may be significant. I've advised my client that, potentially as a matter of discretion, she could be responsible for some of that expense, although equitably, I don't think that would be fair. But there's really no other way to address the situation. Regardless of the expense, the principle is significant. This homeowners association is not operated lawfully, falls far short of UCOBRA. And frankly, the fact that it is operated in that way, I believe constitutes a fraud because the homeowners association implicitly represents that it is a lawful entity and continues to charge these homeowners dues when their operations are far short of Kansas law.
Well, those claims haven't been fully litigated though, have they?
That's correct, Your Honor, but I believe the record before this court establishes that Delaware Ridge Homes Association has not complied with UCOBRA in many respects.
Well, I thought that ruling was still outstanding by the district court. This is only an appeal involving the denial of a receiver.
What ruling would that be, sir?
That this appeal deals only with the appointment of a receiver.
Yes, that's true, Your Honor. But from the district court record, many of the deficiencies insofar as Delaware Ridge Homeowners Association compliance with UCOBRA have been established.
Have they been established by the district court or just by your allegations of discovery?
Delaware Ridge Homes Association doesn't dispute those allegations.
No other questions.
I have lost track, but just for the record, do I have some remaining rebuttal time?
Yes, you still have your 3 minutes rebuttal because we had extra questions.
Oh, thank you very much, sir.
Okay. Are we ready to hear the appellee, Mr. Hoffman? Are you ready to begin your argument?
I am, Your Honor. Thank you. Can you hear me okay?
Yes.
Good.
You may proceed.
May I please the court? It's a pleasure to be with you today. This has been an interesting case. I want to address a couple of comments that came up just during the previous 10 or so minutes. The first is, you may see from the record that immediately upon filing the notice of appeal, and I filed a motion to dismiss because, in my opinion, the appeal is premature. The first pleading in the appellate court by the appellee, Miss Maddy, was that she's waiting on a journal entry to be finalized before she can finalize the issues in front of this court. It seemed to be a very clear admission that the appeal is not right. The second thing I want to follow up on, as indicated a few minutes ago, there's not been any findings of fact in the trial court that indeed there is any violations of Kansas law regarding the operation of the Homes Association. I want to provide a little background. It's very clear to me that you know and are aware of the facts, but want to provide just a little bit more understanding of what Delaware Ridge subdivision is. It was created in about 2003 by a developer who bought a tract of land about 2.5 miles west of the NASCAR track. And if you've been there, you probably are familiar with the area. You know, it's still quite urban, or excuse me, quite rural. There are pockets of residential subdivisions. There's a very nice new elementary school in the adjacent neighborhood. But Miss Maddy's home still faces a cow pasture. It's still a mixture of rural and urban. And what happened was, when the development was created, the home sales were slow because there are so many other opportunities for home buyers in Western Wyandotte County to buy. There's Piper, Tonganoxie, Lansing, Bonner Springs, et cetera. So the sales were slow. Then we got hit, or the development got hit by 2008 in recession, and things just stopped. Home sales, I'm guessing, did not hardly any occur until 2013, 2014. Finally, things have got to the point where this subdivision is nearly complete. I'm a little embarrassed that I did not provide to the court in our briefing materials a copy of a brief sketch of the subdivision. But you asked about how many lots are in the subdivision. It's intended to have about 600 home sites. About 200, as Mr. Lillich said, will probably be single-family home sites. Another group would be duplexes. Another group would be townhomes. And they are phased in various areas of the subdivision. The orange area that I've outlined is what we call common area. It's drainage swales, low-lying areas that are treed. The association owns islands in some of the streets. It owns a playground at the northern area of this orange tract. It owns even a little bit of a Indian burial ground in one of the lots. And then each of the other residential areas, the duplexes and townhomes, have what we call sub-associations. They have additional governing documents that control some of the services that they provide, such as lawn mowing for their individual properties or snow removal. But the overall subdivision takes care of the maintenance of these common areas, and that's what the reason is for the annual assessments. So the developer, when they create a subdivision, records a declaration, and it says every lot described in this declaration is going to be a member of this homeowners association, and they pay dues. Miss Maddy was one of the first buyers. She bought in about 2004. In about 2015, the Owners Association asked me to file a lawsuit against 3 or 4 owners in Wyandotte County who hadn't paid their dues, including Miss Maddy. We filed those lawsuits under Chapter 61. Miss Maddy filed a counterclaim that removed the case to Chapter 60, and we've been there now for 5.5 years. The association in the interim has continued to collect dues, maintain these common areas. And as far as I know, I know they have not asked me to file any other suits for unpaid assessments. As you know, the only issue on appeal is whether or not Judge Mahoney erred in not appointing a receiver. The case was nearly 3 years old when Miss Maddy asked the judge to appoint a receiver. And as you know, under Chapter 60, under 60-1304, an application for a receiver should include some general character, a description of the general character and probable value of the property or business, which would be the subject of the receivership. Although I thought the application was quite deficient in that regard, Judge Mahoney thoroughly considered the application. And you can see by his opinion dated September 25, 2019, he really gave this a lot of thought. He looked at the applicable facts, he looked at the applicable law, and he analyzed the law in comparison with the facts. The standard today is the abuse of discretion. Did the judge abuse his discretion when he declined to appoint a receiver? Well, what's interesting is he cited a 1946 Supreme Court opinion called Guyman-Hartland Furniture about the appointment of a receiver, and Miss Maddy cited that same case in her brief. The judge said there are several elements that he needed to consider when he's going to be asked to appoint a receiver. He said there must be some evidence that the receiver is necessary to do a couple of things, perhaps. One would be to prevent fraud, or alternatively to save the subject property from material injury, or alternatively rescue the property from threatened destruction. There must be some evidence. That's the first thing he asked. Was there any evidence? The second is, he said, in addition, there must be no other remedy. And third, he said, the receiver should not be appointed if it's likely to cause a greater injury than is maybe taking place right now. He concluded that there were only mere allegations of fraud. There was no actual evidence of fraud. And he concluded that the appointment of a receiver would cause unnecessary costs to the homeowners association and a delay to the litigation without any real benefit. Well, he was correct. You know what? There was never any evidence presented to him under oath or any other way about the necessity for a receiver. We didn't have an evidentiary hearing. Miss Maddy didn't request one, She didn't testify. She didn't ask any of her neighbors to testify. She has never taken any depositions of any fact witnesses or any witnesses in this case. The judge simply has no evidence in front of him to consider any of these factors about the appointment of a receiver.
Can I ask a quick question, Mr.
Go ahead.
Hoffman? And this is just kind of a sequence of events kind of thing. When Ms. Bai was thrust into this case, did he also concurrently consider appointment of a receiver, or was Ms. Bai there in place as a facilitator before the issue of a receiver came up?
Your Honor, it's been 3 years ago and I don't remember.
Well, and anyway, what's your understanding of what Ms. Bai was supposed to do here?
That's a great question. And, when the judge had to analyze whether or not he's going to appoint a receiver, he said one of the things that he analyzes is, are there other remedies available? And the appointment of a facilitator was a perfect remedy. It was so simple, so easy, because the facilitator that he selected was somebody that had been a president of a homeowners association in Western Wyandotte County and could read declarations. She was a court employee, maybe still is a court employee, and the court had quite confidence in her and her abilities to look at things. She was so good, in fact, that she discovered something that none of the rest of us unfortunately had discovered. But I showed you that map of the subdivision, and the way subdivisions are developed is a developer takes the first portion of the tract that he buys and records a declaration. And if he's successful, then he takes that document and files a document that annexes the additional land of the subdivision to be covered by the first declaration. And then he hopes he's successful, but he doesn't develop the entire area under one declaration at one time, because if the thing is not successful, he may find that the declaration needs to be altered. Well, what Ms. Bai discovered is that the developer, as he put streets and sewers into the subdivision, neglected to record an annexation document to annex all of the subdivision into the Delaware Ridge. And so she said, Judge Mahoney, there's no reason right now for me to conduct an election until we're certain that everybody that lives within the physical boundaries should be able to go vote. And so it's my understanding, I don't work for the developer, but it's my understanding that the developer has been working to get that problem solved. And so it's my hope, and I hope it's the hope of Judge Mahoney, that once that problem is solved, then the facilitator could go back in and notify homeowners that it's time to have an annual election to elect directors. But that was the first remedy available outside of a receiver, and it was at a very low cost. She was told that she should send her invoices to the homeowners association. She was told that they would be reimbursed, and she wasn't reimbursed for her time. It was a pretty inexpensive remedy. But the other remedy available to the Miss Maddy in this case is a trial on the merits. This case is 5.5 years old, and guess what? We've never had any case management conference to schedule a deadline for discovery. We've never had a case management conference that would discuss a trial date. If she has legitimate counterclaims of under I can't pronounce it, but under Kansas law affecting homeowners associations or any other law, wouldn't she want a trial? The other thing that's so interesting is, if this was really an emergency, wouldn't there be other homeowners just knocking on the door saying, Judge, I agree with Miss Maddy. You've got to do something to protect us. There's never been even any photographs of the islands. And somebody would say, Judge, look at this junk out here. There are weeds in the islands. Look at this playground. It's not safe. The Owners Association is maintaining those things. The Owners Association is insuring the playground in case anybody would get hurt. The Owners Association is collecting dues. They use a third-party contractor to collect dues to make sure they have accurate financial records. Nobody is complaining that the association is a sham, with the exception of Miss Maddy. If she thinks it's a sham, I believe that this court should simply remand this case back to the trial court for a trial on the merits as soon as possible. Thank you. I'm done.
Thank you. We appreciate. Are there any questions from the other judges? Mr. Lalick, we're ready for your rebuttal.
Yes, thank you, Your Honor. I've started my watch again. And again, I appreciate the time for rebuttal. Mr. Hoffman has pointed out on behalf of Delaware Ridge that there has not been litigation at the district court level to establish the facts of this case. But based on the pleadings that have been filed in this case, Delaware Ridge Homes Association doesn't dispute that their operations have been deficient insofar as the requirements of UCOBRA. There is no disputed fact that they have not maintained regular homes association meetings as is required by UCOBRA. They do not have proper bylaws as is required by UCOBRA, nor have they complied in many other respects as is set out in the pleadings from district court and in our brief. They have not complied with the basic due process requirements per UCOBRA for the homeowners. Mr. Hoffman, on behalf of Delaware Ridge, also pointed out the analysis that Judge Mahoney did with respect to my client's request that a receiver be appointed. I think it very significant for this court to note that that analysis came in September of 2019 in the form of a memorandum after my client had already appealed this case. The determination on the journal entry from the October 30th, 2018 hearing was by a hearing in August of 2019. Following that hearing, I appealed the denial of the appointment of a receiver on behalf of Ms. Maddy within the 14-day period of time. That analysis did not come from Judge Mahoney until the following month, as I recall, in September of 2019. Something else that I think is significant to mention is that with respect to Mr. Hoffman's claims that the application or petition for the appointment of a receiver was deficient, that those objections were not raised at the district court level and were raised only by the appellee in the pleadings and briefs that were filed with this court. And on that point, and something else that is significant, is that my client is presently in the process of considering whether or not to directly seek the appointment of a receiver by this court pursuant to KSA 60-1301, which extends statutory authority not only to the district court, but to the Court of Appeals and or the Supreme Court to appoint a receiver. The state of affairs of this homeowners association cannot continue. It's not proper. It's not consistent with Kansas law. And the current management of the homeowners association, which is developer driven, has taken no effort to remedy the state of affairs.
Counsel, isn't it a common practice for the developer to maintain management of the homeowners association until the development is done or near completion?
Yes, it is common practice, Your Honor, but that time is long past. In fact, the declarations themselves that were made by the developer put a limit on that time period to 2013 to turn over the homeowners association to the homeowners. And this is part of the record before this court. That did not occur. So the developer has continued to manage the homeowners association outside of the authority that it granted itself. And not only that, Your Honor, it continues to manage this association in a manner that is deficient for the requirements of UCOBRA.
Thank
I
you.
believe I'm happy to answer any more questions the court may have, but in looking at my time, I believe I'm at the 5-minute mark.
That's correct. Judge Schroeder, do you have additional questions?
I do not.
Well, you have reached your time limit as far as rebuttal. We appreciate the arguments that we received from the parties today. We'll take this case under advisement and get your opinion as soon as possible. And we appreciate your arguments and have a good afternoon.